Sir William Seal.
Mr. Speaker, I suspect at a time when this country of ours is faced with a housing crisis and that the leaky home scenario has been around for quite some time, it would be premature, sir, for government members to be patting themselves on the back and claiming that this is a wonderful piece of legislation, even though it may be. Because I suspect, sir, that the thousands of people who have experienced the leaky home and who have been fighting to try and get claims from their council, from central government, will not feel as optimistic as the government members might feel. So I think it was the Homeowners and Buyers Association who said that the term leaky building, quote unquote, has now been in the Kiwi vocabulary for 10 years. And that's an indictment on the pieces of legislation that enabled the buildings to occur in the 1990s. And yet today the country is still struggling to come to grips with the reality that many of our homes built in the last 19 years or before 2006 are seriously defective and in need of repairs, which often cost hundreds of thousands of dollars. The initial response, just by way of background, to the leaky building crisis was the introduction of the Weathertight Homes Resolution Services Act in 2002, which was later replaced by the 2000 Act in force today. This act was intended to provide speedy, flexible and cost-effective procedures for assessment and resolution of claims relating to leaky buildings, as opposed to using privately engaged building surveyors in the courts. In April 2009, the national government engaged PricewaterhouseCoopers to produce the report on the size and cost of New Zealand's weather tightness problem. The report, released to the public late in December 2009, found that the likely number of homes affected was in a range from 22,000 to 89,000, with a consensus focus of about 42,000 failures at an economic cost to repair of about 11.3 billion. The report also recorded the view of many experts that the majority of monolithic clad dwellings constructed before 2006 would suffer from weather tightness issues, making the total number of failures in excess of 110,000 homes at an estimated repair cost of about 30 billion. So many experts in the building industry suggest that this figure is more likely to be the case and even understate the size of the problem. As a response to the Minister of Building Construction, Maurice Williamson at the time, announced the financial assistance package for leaky homeowners in May 2010. And under the package, an eligible owner will get a contribution of either 25% or 50% of the agreed repair cost if they can prove their ability to fund the balance. The financial assistance package has been described by the Prime Minister John Key, and I quote, as spreading the cost as evenly, as fairly as possible. And he suggested that this is the solution to the leaky homes problem. So many in the industry, many homeowners, and those who are facing leaky and defective homes do not consider this to be the case at all. Standalone homes constructed or renovated more than 10 years ago, under the New Zealand law, owners of more than 10 years old have no chance of recovering the cost of repairing their home from those responsible for the faulty construction. And to be eligible to use the government system for assessment resolution or to take up the financial assistance package, a home has to be built within the last 10 years. And this was a statement, Therefore, owners whose homes are more than 10 years old are left to bear the full financial burden of repair by themselves. And there are situations where homes may not meet the eligibility criteria for the government system, but may still have a viable claim in the courts. Standalone homes less than 10 years old, certified by council, and where the council's been responsible for the certification of a home, they owe a duty of care to the owner, no matter whether you are the first owner or a subsequent owner. And as a result, owners in this category have the opportunity to recover a significant portion of the repair cost from the local council and any other original party still in existence, either through the government, Weathertight Homes Tribunal or the court. And where the council is found to have breached its duty to the owner, it will usually be found liable for 100% of the total amount awarded, with the opportunity to recover a portion of this from other liable parties. For those with joint or several liability, an owner gets paid all that is owing to them if others default. But under the financial assistance package, an eligible owner in this category would only receive a contribution of 25% of the agreed repair costs from council, and the same from government, as long as they can prove their ability to fund the remaining 50%. And standalone homes less than 10 years old, certified by a private certifier, where a home was certified, by a private certifier, unfortunately local council owes no duty of care to that owner, as all the private certifiers are now in liquidation or are struck off, and in many cases the other parties involved in construction are also long gone owners in their category, often have no chance of recovering their repair costs. And I state that because I have owners of leaky homes in my own electorate, as I'm sure other members have. And so to talk to them about this after many, many years of trying to get a claim through, it's just distressing for them. They just don't have any confidence whatsoever that they're going to see a light at the end of the tunnel. So yes, absolutely, Mr. Speaker, the Labour Party supports this legislation. We'll support it to the Select Committee. It is important for the government of the day to attempt to try and serve the very communities that is hurting at the moment. Housing is such a significant issue, sir, that this just compounds the state of dire need that many families are facing. It's just been going on for far too long, and we've got another bill before the House that hopefully is going to fix this. Far too many families have lost their homes and their livelihoods as a result of the leaky home saga. I want to say, sir, that in a Paul Holmes interview and this is one of the reasons why I said at the beginning that it would be too premature for the government members to be patting themselves on the back for this piece of legislation. Paul Holmes, the late Paul Holmes, in a 2000 interview discussing the legal homes crisis, said it was the Bolger government that passed the Building Act of 1991 and that allowed untreated timber, monolithic cladding, to be used on homes. And I think Sir Maurice Williamson, of all the members on that side of the House, will know, because he too admitted at an interview during this saga that there was fault played in the government when they deregularised the building industry, and there was no oversight, oversight in terms of ensuring that the quality of the homes that we were building are to the highest standard. So I've got the Labour Party, sir, has no problems. The bill clarifies that the claimants are not eligible for government contribution to the financial assistance package while pursuing a civil case against a participating territorial authority unless that participating territorial authority agrees and they discontinue legal proceedings. So I think we do need to state clearly for all those concerned, sir, what are their rights. I would hope, sir, that when this bill comes through the Select Committee, that the opportunities are given to every organisation, home buyers, homeowners, organisation, to have the opportunity to make their submission to this. I would hate to see the Select Committee rush this, analysing this bill through. As much as they may want to, I think it's taken us for so long to arrive at this stage here that I think we do need to get it right, and in order to get it right, it is going to be important for homeowners, home buyers, all of those in the building industry that have a stake in this, in the leaky homes situation, have a stake in the industry going forward, that it is important that we give them every opportunity to participate. Thank you.
Before I call Paul Foster-Bell, and without breaching the convention referring to the absence of members, I do know that the previous speaker has been wasn't here for part of the time in the last session when the Speaker was very clear on a ruling he gave as to the reading of speeches. I didn't interrupt the member for that reason, but I do want to just give a general warning again for those members who didn't hear the Speaker. Paul Foster-Bell.
Mr. Speaker, thank you, sir. Sir, contrary to some of the things